defendant have said that the difference between the sculpture, the photograph of sculpture and the photograph of the painting. Yeah, is it the difference between, you say that it is different between...
Wait, objection. Do not indicate them. You talk to the jury, not to the defense counsel, okay? Right? Do not mention them as you. You are the jury, not the defense counsel. Right.
The defendant has said about the photograph of sculpture and the photograph of painting, and they say that it is different. Maybe they say about the difference between two-dimensional photograph and three-dimensional photograph. I don't think so. Why do you think that when you put a photograph and you capture a picture or you capture a sculpture? I don't think that. When you want to capture it, you have to spend time, you have to use your experience to make a picture very beautiful. And even if you also, and how you can draw the line between the three, how can they draw the line, the difference between the two-dimensional picture and three-dimensional picture? I don't think so. And the other thing that they say that our picture, our photograph, it's just some collection to make a slide. No, I don't think so. We had to spend a lot of time. We had to spend a lot of money, and we also had to rent the experienced photographer to make a collection of the photograph. And even when you know in the work, when you want to make a work art, you have to capture it, to make a collection and also
based on just what's the argument.
Okay. They want to know what your argument is, but that's not the objection.
No, I mean we have responded to the argument last time.
You did. Okay.
because I will.
Yeah, you can go. You can do it again. It's up to the plaintiff. Yeah, they have their choice.
Do them and then
Yeah,
leave the
no
next
problem.
or...
Yeah, no problem. You can go ahead.
And firstly, the defendant also mentioned about the Berne Convention. I think that United States, they have joined in the Berne Convention, and also their copyright law, their copyright act also follow the Berne Convention. In the supreme powers also adopt it in the copyright laws. Is it constitutional?
Well, before we get go on, I want to tell you. It seems like every time we talk about many issues at the same time, like international law issues, like medium change issues. I don't think that's a good idea. You should come up with one issue at one time. Okay? Right? We cannot go on with a lot of issues altogether. I think that's a better idea.
I think that in my issue, I just want to prove that our reproduction is copyrightable.
Right, but to prove that, number one, International Berne Convention should apply. Number two, even though there is some sort of a dimension changes, still the copyright should protect this picture like that. Those things are totally different issues, right? So we think you must go on one issue at one presentation so that they can respond. Okay? You can argue one issue, right?
As the judge mentioned about the plaintiff's argument, they suggest two point of view, two issues. So, but we cannot respond about that in same time. So I just want to tell about the first issue. They still repeated their argument that the three-dimensional art and the two-dimensional art is basically same on the copyright issue. But I think that's a totally different problem. Because when I take a picture, just assume that this desk is a sculpture, and when I take a picture from this angle, and in front of the sculpture and left side. Maybe the result will be very different because it's the three-dimensional art, three-dimensional some sculpture, so very different from the angle. But in two-dimensional art, two-dimensional painting, it's the same. Which angle, it doesn't matter which angle you took a photo. Just all we want to know is the contents and contents of the paintings. So their repeated argument is cannot be applied to this case. And they also argue about the effort, but the arrangement and effort to make their collection it gives no difference from the real paintings. Although our customer too want to know about the paintings, but they still argue with the copyright, with the arrangement, the way of arrangement. Is there any special in their way of arrangement? No, absolutely no. So I claimed that strongly again, in their photos with the contents of the real painting, original painting, very famous painting, there is no copyrightability. Thank you.